Hey everybody, it's attorney Veronica McClendon coming to you live from Macon, Georgia. I'm here to talk to you about a topic that a lot of people don't really want to think about, but we all need to think about it, especially if we have young children or if we have young grandchildren. The issue that I want to talk about is what happens when a child inherits property. And when I say a child, I mean someone under the age of 18. What happens if they inherit property either from a parent or a grandparent? Can they actually inherit that property? I think that's something that a lot of people don't really think about. You talk to most parents and they say, when I pass away, I want everything to go to my children. And they assume that it's going to happen automatically. And yes, under most circumstances, it will. Because when someone dies without a will, their property will typically be distributed between their surviving spouse and their children. And if their children are minors, then they are going to be entitled to what's called a year's support. And that's the same thing for a surviving spouse. They're also entitled to a year's support. I have to add a caveat. This is Georgia law, so other states may have different rules for year support. They may not even have a year support. So you got to make sure that in your home state that what I'm talking about makes sense. And the way you do that is by talking to a lawyer who is licensed in your state. So I kind of got ahead of myself a little bit because what I'm talking about is what happens when a child inherits property from a parent's estate or from someone who had a will and they left property to a child, or even if they didn't have a will, it could be a grandparent who their child has died. And so after the grandparent dies, their heirs may be their grandchildren or may include their grandchildren. Because here in the state of Georgia, if someone dies before their parent, and that parent later dies, then the heirs of that parent, I guess the grandparent in this case, some of them will be the children of that deceased child. So to make it more clear and straightforward, I hope, if a person has a child who dies before they do, and that child has children of their own, those children of the deceased child are going to be part of the heirs for the grandparent after they die. And so, what happens if they inherit property? This is a situation that I have encountered quite a bit in my practice, where you might have a parent who dies, and then the grandparents are even taking care of their grandchildren, or maybe they're not taking care of their grandchildren. Someone else is, maybe the surviving parent is taking care of the grandchildren. But then that grandparent later dies, and they don't have a will, and their grandchildren, who are minors, inherit a part of their estate. Same thing can happen for a parent if they unexpectedly die, or they die for whatever reason and their children are still minors. Those children could inherit property from their parents. A common situation that we have is when someone buys life insurance and they name their child as a beneficiary on their policy. If their child is still a minor, can that minor child inherit the benefits from that life estate policy? And that's something that's really important to think about, because here in Georgia, a child cannot inherit property from an estate. So let's say that a parent dies and they had $100,000 in the bank account. They had 4 children and they didn't have a surviving spouse. They did not have any adult children. Those 4, those 4 minor children would each be entitled to $25,000, or at least 1/4 of whatever their parent left behind. They would not legally be able to receive that money for themselves. And so the court would have to appoint a conservator to manage that property for that child. Same thing if a child inherits property from one parent, perhaps, and their surviving parent is still living, but that surviving parent, they only can receive up to a certain amount of money on behalf of that minor child. So if the amount of the inheritance exceeds what that parent can receive on behalf of their child, then the court would have to appoint a conservator in that situation as well. So if you have minor children, either who are your direct children or you have minor grandchildren, you really need to make sure that you have an estate plan in place. And when I say an estate plan, it needs to include either a will or a trust. And not only does your will or trust need to be part of your estate plan, you need to make sure that you have a special provision in your will or in your trust that says that if any of my beneficiaries from my will or my trust are underage, I want their part to go into a sub trust. So you have the option of creating a will, and you can say, I want the property to go to these three individuals. If one of those three individuals is a minor, one or more of them is a minor, you need to say, instead of it going to them directly, that it goes to them in a trust. And you can name someone to be the trustee of that trust. And so the property will automatically go from the deceased person's estate to that minor child in their trust. And the trustee that you have named in your will or your trust, that trustee will be responsible for managing the property on behalf of that minor child. So that's a way to keep the court from having to appoint somebody. And it's also a way to keep the person who is appointed as conservator. Well, let me scratch that. It keeps the person who's over the child's money from having to report to the court. Because if you are the conservator of money held for a minor child, you have to go to court every year to report on how you spent the money for that minor child. You have to have good records. You have to make sure that you show this is how I spent the money. And if there are certain kind of purchases that you make, you have to get the court's approval before you can make that purchase. Because if you do it without that, then you've, I can't remember what it's called really, but there's a term for when you use money that you're not supposed to use, that the court hasn't pre-approved. Actually, I think I'm getting it mixed up. So there's a process that you have to ask the court for permission, I think, to encroach on the property. Y'all don't quote me on that. I don't do guardianship and conservatorship anymore. Temporarily, for the past few years, I haven't done it. So I'm kind of just spitting words out. But y'all don't even need to know those words. What y'all need to know is if you are conservator over someone's property for either a minor child or an adult who is disabled, you have to go to court and report to the court every year. And you have to make sure you keep good records, and you have to make sure that certain purchases that you get the permission of the court before those purchases are made. And you can just imagine how much trouble that is. You might have to hire a lawyer. You have to take time off from work to go show up in court. You have to keep good records of how you spent the money, which for most people, it won't be an issue that they have to keep records, but the kind of records you keep may not be the ones that the court wants you to keep. So you're going to be coming before the court every year having to account for that. If someone leaves the money to the minor child in a trust, then the trustee is not responsible to the court. They may be responsible to other people in the estate, depending on how the person's estate plan was set up. They may have some accountability measures in there, but they're not going to have to come to court, pay court fees, hire a lawyer, do all of those things. They might need to hire like a CPA or a tax preparer or a bookkeeper, but they don't have to go through getting a lawyer and going to court and paying those fees and things. So this is very important. A lot of people are kind of thinking, well, I don't really own much, and so I don't really need a will, or I don't need a trust because I don't own a lot and I know everything is going to get to my children anyway. Or a lot of people are just not thinking that there's the possibility that they would die before their children reach the age of majority, and they're just not thinking about creating special plans for their children. But you really need to think about it, because I've worked with several families where the courts had to get involved, and it just drags the process out unnecessarily. Things that could have been done very quickly now take several petitions that you're filing in the court, and you have to, if you need to sell something on behalf of the minor child, you have to ask the court for permission to do that. There are so many different things that have to be done if you're having to report to the court on behalf of this minor child. Another issue that could come up is that, let's say you name your minor child as a beneficiary on your life insurance. That money gets paid out after you die, but then the life insurance company is going to say, well, we can't give this to a child. Like, we need somebody who's going to be over the money. And there's something else that I actually should have mentioned before. It's called a custodial account. And so there's certain types of accounts that can be created without having to have a conservatorship. But that's not something that you want to be trying to figure out. Can I get a custodial account? Do I need a conservatorship? Because there are some situations where you might think you can qualify for a custodial account, and the court is like, no, because you didn't meet these criteria. So let's just not even have to go through all that, and make sure that you have estate planning in place that says that if I have minor children or minor grandchildren or anybody who's a minor, it could be a niece or nephew. You might have decided I'm going to leave something to my sister and she's an adult, but then you didn't realize your sister would die before you did. And then now her part goes to, or she might die after you do. And I'm mixing it up. Y'all excuse me. Y'all know, if you watch my videos, you know I be talking and thinking at the same time. If you left something to your sister and she died and she had minor children, then her minor children could end up inheriting what you left for her. And there's so many different scenarios that you just may not think of. I had a situation where two people in the family died within a week of each other. And so we ended up with minor children coming into one of the estates that wouldn't have even been there if the course of events had been just a little bit different. So what I'm saying is, it's important that if you have minor children, for sure, that you have an estate plan in place to make sure that whatever you leave to them, whether you do it directly through like an actual will or trust or life insurance benefits, or if it happens by virtue of state law because you didn't have a will or trust in place, then you want to make sure there's provisions made so that your children are not waiting on getting money, or the people who are taking care of your children are not waiting to get money from your estate and fighting for months and months, maybe even years, trying to get money from your estate. So if you plan ahead by doing this planning, then you can avoid that for your family. There was something else I wanted to cover. Can't remember it now. So what I'm going to do is just say, if this was helpful to you, please like this video, subscribe to my channel if you are not already subscribed, and share this information with someone who might benefit. The main point of this I'm saying is that you need to make sure, if you have minor children, that you have a will or a trust in place so that if something happens to you, your children are still minors, your grandchildren are still minors, that you already have provisions in place to set their money aside in a trust or even a custodial account if it makes sense. But you get to be the one that directs it without having to get the court to approve it. Because every time you go in front of a court for something, you're paying some kind of a fee, you're spending some kind of time, you're going through some kind of a hassle that you can avoid by having an estate plan in place. And even if you don't have minor children, you need an estate plan. We all need to have some level of will or trust in place. I have a few estates that I'm working on now where the person died because of some kind of an accident and there was a personal injury claim. And now their family is having to get an administrator appointed over the estate to receive the funds from that personal injury claim. They didn't know they had property when they were living. They didn't know that they were going to have any kind of money because they didn't have their own property while they were alive. So they had no idea that something crazy was going to happen and then there'll be a lawsuit filed and that their family would be able to receive a settlement from that lawsuit. If you have minor children involved with that, which I've seen happen quite a bit, then those minor children are going to have to get conservatorship and have to get certain things in place in order to receive the money from that settlement. So these are things I want y'all to think about. Again, if you wouldn't mind, subscribe to this channel, like this video, share with somebody who might appreciate it. Y'all take care.